Well, I just wanted to thank everybody for coming. I know it's early, but the fact that we have this kind of crowd is we're very much appreciated from PAJ. A couple things I want to do just in terms of housekeeping is just make sure everybody has their forms, make sure that you sign it, make sure at the end you give it to the staff people here at PAJ. We want to make sure that everybody gets their credits. A couple things. First of all, you'll see that this is being filmed. We have the assistance of our business partners, and I think you probably will have heard throughout this retreat how important the business partners are. They're a vital part of our organization in terms of keeping us financially sound. So it's important, very important, that we patronize them, that you talk to them, that you find out about their services, and then if you give them a call, and they can really help you out in terms of your litigation needs. First of all, I just want to tell you that Precise Incorporated is here. They're a full-service litigation support company specializing in electronic discovery, trial presentations, custom graphics, medical illustrations, and animations. And we use them in my office, and they're great, so I would recommend them highly. We also have our sponsor of this program is Garrettson. Mike McCullough is here from Garrettson. I'm just going to have Mike come up and just give you a 30-second pitch about his company. But before I do, Mike, I just want to say that my office has been using Garrettson. We do some mass tort work. They've been instrumental in helping us get the situations resolved in terms of cases. So, Mike, why don't you take it and just tell folks what you do.
Thanks, Ken. Nice and loud there. Thanks, Ken. First off, we really appreciate the opportunity to sponsor this program. And also, we've been involved now with PAJ for a number of years, and this is a great organization. I personally am involved with about 15 states organizations, and by far, PAJ is the best out there. No doubt about it. Well-organized group. As far as Garrettson, one of the things that you folks deal with on a day-in, day-out basis is the bottomless pit of nowhereness called Medicare. And our goal is ultimately to help plaintiffs' firms navigate Medicare and get the process done from start to finish as efficiently and as clean as possible. So again, I appreciate the opportunity to come up here and just speak for a few seconds, let you know that we are out in the hall at booth, and I'm more than happy to help you case by case along the way and get you through the process. So thank you very much.
Thanks a lot, Mike. Let me just tell you how this course came about. As a lot of you probably know, I'm the incoming president of this organization, PAJ. And when we started planning this course about 3 or 4 months ago, I sat down with Lisa, and we talked about what kind of programming do we want to have. And when I think about programming, since we're all required to fulfill the Supreme Court requirement for CLEs, what I thought about is, what would I want to see if I came to a course and had to sit for a couple hours and listen? What would I want to listen to? And what I thought about was, things about trial, perceptions about, what you need to do, what the reality is, what the unreality is, and just all the thought process that goes into a trial. And when I thought about that, I thought to myself that the person that I would want to hear from is a person who's done it year after year after year in all over the state, both in Philadelphia and all of the counties in Philadelphia, and that person's Tom Kline. Tom's been my friend for probably 25 years now, and I can tell you the first time I met Tom was about 25 years ago, and it came as a result of a course. Jerry Litvin had given me a call, and he was putting on a course, and it was called Maximizing the Verdict. And he had 5 of us give closings. I was a young lawyer at the time, and I met Tom for the first time, and after I gave my closing in front of the group, Tom went up and then he gave his closing. And I knew at that time that there was just something very special about him. I was captivated by his approach. I was captivated about the way he strung the story together in order to tell the story about his client. And I said to myself, this is a guy that's really special. He's been great to me over the years, and I said to Tom, I'd like to do this course. Let's give it a shot. Now, I have to tell you something about this. There's absolutely nothing about this that's rehearsed. As Tom is sitting here, he really doesn't quite know exactly the questions that I'm going to ask him. And for someone like Tom, that makes him a little crazy. Because I think what you'll find out is the reason why Tom Kline is a great lawyer is because he prepares. Pretty hard to prepare for this. We spoke briefly last night, and he said, what do I need to do? I said, you just need to just basically answer the questions. I mean, the preparation really came from me. I was up till 2:30 preparing, thinking about the questions that I wanted to ask. So understand that this is kind of all the thoughts that I have with regard to questions about trial that I wanted to, kind of shoot at Tom. So we're just going to, the whole purpose of this is to get his perspective on trial law.
I was fast asleep.
I'm glad you were, Tom, because as you were sleeping, I was up writing. Tom, when I thought about it in terms of trial work and the qualities that a trial lawyer, needs to have, what would you think would be two of the most important qualities a trial lawyer needs in order to be effective in a courtroom?
Well, the first quality of any good trial lawyer is consistency and discipline. When you're in a courtroom, you're in a very disciplined, very structured environment, and you have to know that that's where you are and what you have to do. The second thing, which is a branch off of what I think is an important quality in life generally, which is loyalty, is sincerity. You have to be sincere to yourself, to the jurors, and to the court, and honest. People see that, they recognize it, they know it right away. I've oftentimes, in fact, I think I remind myself of this almost every time that I set foot in a courtroom and I see a jury. I view our reservoir with any jury as a glass less than half full. We're the subject of ridicule. We're the subject of propaganda. We're the subject of a lot of things that demeans lawyers generally and trial lawyers specifically in the public view. And so when you walk into a courtroom, I view our job as diminished in that way by the fact that we literally have to go in there and face the glass half full with every jury. I'm not talking about county by county, I'm talking every jury. And so I view it as mistakes or loss of credibility as being fundamental not to allow to happen. And that means that the very fundamental building blocks that you live by, which are honesty, loyalty, integrity, are magnified in that setting, magnified to the point where you really need to understand and you really need to focus on never losing it. And of course, you can lose it in many ways, and people who are part of your case can lose it for you. And it's very hard, and the way I've conceptualized it over the years is it's very hard to put any additional fluid back in to get you over 50. Now you know it, sometimes you're trying that case, and sometimes your opponent has made those mistakes, and sometimes the credibility scale has swung, and you just can feel the water at the top when you're going to the closing speech. But boy, I've also been there when you feel the water at the bottom.
Well, that's interesting. So do you think when you first get up, before even a word comes out of your mouth, that jury basically has a negative perception about lawyers in general, which would include you as you stand up?
I think that the public polling would demonstrate that, and I feel that that's the case. I think there are certain impediments that you have to overcome even beyond that. If you're outside of a county, I know there have been PAJ seminars on out-of-county presentations and how we go about it, sort of how we go about remaking ourselves if we're Philadelphia lawyers, quote Philadelphia lawyers. But the fact of the matter is that you have to approach jurors as you approach people in general in life. And that means that you have to be forthright and direct. That means confronting the problems in your case up front. That means going into an opening speech when you have a client who is contributorily negligent and addressing that issue. Knowing that you have a problem, facing it, determining how you're going to mold and shape that is all part of being a lawyer and all part of being a successful trial lawyer. I think that we learn the most in the courtroom from the mistakes that we've seen in the courtroom. And I'm sure I see a lot of friends in this room today who have tried a lot of cases. And I know that all of us have seen those mistakes and we say, I'm never going to let that happen to me. because you see it in the juror's face, you see a wince, you see a body twitch, and you know that it's rubbed somebody either the right or the wrong way. We all look for those things, and sometimes they're telling and sometimes they're not. But the fact of the matter is that we need to approach things, at least in my view, that way.
I'm going to ask you a little bit later, Tom, maybe about some mistakes you made. I won't ask you that right now. But you had said sincerity being one of the key things that you want to project when you're in a courtroom. How do you do that? I mean, when you first get up, if that's one of your goals right from the get-go, from the first time that you stand up and you address that jury, what do you do? I mean, what are you trying to achieve to get them to understand that you're sincere and forthright about your case?
Well, this may seem fundamental, and it may even seem elementary, but my view is that you, in the first instance, need to be polite, and you need to be low-key, and you need to be the kind of person that the people who you are now looking in the eyes of, and I mean looking in their eyes, that those people believe that you are the kind of person that they would like to spend time with. A problem that develops, and something that I've seen over the years, because I've seen it with opponents in the courtroom, and I've seen it with co-counsel on the same side of the table as me, is that they try to become too chummy. There's that person who is too ingratiating, too in your face, too supercilious. That's no good either. For me, it's come just trying to be myself. I don't think you can remake yourself into somebody who you're not. There are some lawyers who are gruff and very successful. There are some, and I've seen lawyers like that. I could name names, but I won't. But I know lawyers who I've tried cases against who are very successful, but who are a little rough around the edges and a little tough. But jurors appreciate that, and I've seen it work if they are themselves, if they are loyal and true to themselves. You have to find what's best in yourself, in my view, both in life and in being a trial lawyer. And when you look at it, and we all have to pause. You have to pause, you have to think, and you have to say to yourself, what is it that I want to be and I want to be like, and how am I going to be faithful and true to myself? Along the way, there are many lessons that you learn in life. Obviously, we all have, and you're able to try to structure and mold them into a courtroom setting. Anecdotally, many years ago, my great law partner and extraordinary trial lawyer and best friend Shane Inspector came into me after a high holiday sermon that was given by his rabbi, and he said to me that he heard something which he thought rang very, very profoundly, and it was, it's better to be kind than to be right. And I had it typed out and enlarged about 5-6 times, and I have it on the side of my desk. And I've had it there for years. And jurors, I think, translate that. People, I think, translate to that and respect that. And I think that it's a pretty good creed to live by.
Yeah, that's interesting. Is it important to be liked by the jury? I mean, you said some people have, some people present things in a gruff way, and some people present things in an easier way to, listen to and accept. Is it important, though, in terms of getting a verdict, for the jury to like the trial lawyer?
I think it is fundamentally important that the jury respect the trial lawyer. I think that the key element in the equation is respect. And there's too much emphasis given on being liked. At the end of the day, whether they like you or they don't like you isn't as important as whether they respect you and whether they believe in the message that you've given.
I think that's a really important point, because I think there are a lot of trial lawyers out there that when they try cases, they're trying to ingratiate themselves to the jury. But from your perspective, it doesn't make a difference whether a jury truly likes you. What you want them at the end of the day to respect you.
Well, I want them to like me.
Okay.
I don't want to be disliked.
All right.
But I want them first and foremost to respect me. And there are ways to have jurors, at least as I've seen this in my own mind develop over the years. And One way is to one way is through what I started out this conversation with, which is in a disciplined fashion. They learn an awful lot about you. I usually say in an opening speech to the jury, I'm not one of these people who believes that the person who can work without notes is the lawyer who's most respected. I use notes all the time. And I also, those who know me, have a system which is basically one thought per page, which means that if you have a bunch of thoughts, you have a stack this big. And I often stand up in front of a jury in an opening. I use a music stand. Everybody who knows, there's a number of people, folks from my office, who are great support people in this room today. And everybody knows I need my music stand, because I don't want to have a barrier between me and the jury. There's a whole psychology here, Ken. It may all be goofy, but this is what I do, and this is how I do it, and you wanted to talk to me, so here's how it goes. So I bring the music stand. Then I don't have a barrier, but I have a place for my notes. And I want to be as close to the jury as I can be. I learned that from the late great James E. Beasley. You're like given both an invitation and a license to be as close as the judge will let you be to them. So that's what I do. I get as close as I can to them, but I have my notes, and I tell them in the beginning that I have a job to do. I tell them that. I tell them I was hired by these good folks. And usually there's somebody behind there who is both needy and hurt very badly, either emotionally or physically, by either a death or a horrible injury. And I will say to the jury, this is my job, and you're going to have to bear with me. I almost always say, because usually with me you have to bear with me. And I have usually more than I should say or need to say, and that's me too, and that's maybe a fault, but I then show them usually the stack and say, I have a job which is in an opening speech to outline the facts. And in order to do justice to this family, I need to outline the facts meticulously and in great detail so that you have the roadmap that you will follow during the course of the evidence. And they then see the stack of papers. It's the opposite of a former 30-year senator who takes off his watch and tells you that he is going to give you a false sense of security. That's Arlen's line for many years. I say the opposite. I say, there's a big job here and I have a big stack of paper and you can follow how long I'm going to be. But there's another thing that I'm telling the jury, at least I believe. I'm telling the jury that I have a very disciplined way and I have a lot of facts that I'm going to tell you. While I have been accused, even in opening speeches, of being emotional, of crying in an opening, I know, you're not supposed to do that, but there's no rule that you can't be truthful and honest to yourself if you are moved by something. But I will do it in a factual narrative, because I believe that juries immediately will see through the, pardon the expression, bullshit of argument that you're going to give them in the beginning that has no bearings to the facts, that is determined and constructed to be prejudicial to someone else. And the minute that the lawyer on the opposition stands up and says objection, and the judge sustains the objection in your opening speech, there's a little bit that comes out of that already less than half full glass.
It sounds, too, like when you tell them about the papers that you have and so forth, that you're trying to demystifying the process for them. Is that part of your intention? I mean, because they're coming into a jury box, which is probably the first time that they've ever served on a jury, are you trying to give them a little bit of a roadmap as to what they're going to see over the next, week or so?
Well, I'm going to say something to you that lawyers who try cases against me regularly always say to me, which is, are you going to mention that you were a sixth grade school teacher? And whether I mention it or not, it's ingrained in me. And being a good courtroom lawyer is being a good teacher. There is no doubt about it. They should have in law school, in my view, rather than some of the courses that I've seen taken, like by my now-to-be 3L son, Zach, I would suggest a course in educational teaching methods, which I took, and which focus on not the substance of the material, but how to teach the material. We have a job to do, essentially, which is to educate a jury. And the way you educate a jury is to tell people who have essentially, by and large, not always, you occasionally have a nurse on the jury, occasionally a lawyer on the jury, but by and large, people who are uneducated to the subject matter which you are about to explore, no education in that subject. And jurors very quickly know and understand if you are able to translate it. I often say in a medical malpractice case, we are now going to deal with terminology that both you and I are very capable of understanding, because all we need to do is use words that are not in our current vocabulary and learn how to dissect them. There's no word that you can't learn. Hypotension, hypo-low. And the way that you educate a jury is to tell them that you are the one who they're going to get the information from. And you have the opportunity. Most lawyers in this room are lawyers who represent victims. They're lawyers who have the first shot at telling the jury the story. And there's a great advantage. Jim Beasley used to call it primacy. And it's primacy because you are the one who gets to tell the story first. Someone else has to then deconstruct the story. And I've translated that in a little bit different way, Ken. I believe that we have the opportunity to not tell our story first, but to teach the jury first. And that's what you want to accomplish. That's what you want to be able to accomplish. There are all kinds of subtleties to it and how you go about doing it, and it varies from case to case. Mm-hmm. But you can basically do it. One very effective way is if you call, you have to be careful. I know it's in vogue to call the defendant on cross-examination. I will only do that, and I know this is a little bit in the weeds for maybe this particular conversation, but I will not call the defendant on cross-examination in a medical malpractice case who is going to be a strong witness. What do I need that for? To test his or her credibility against mine? But what I will do in a teaching way is I will say, who is the person who knows the most about this case, who's not threatening, who I can ask leading questions to? Maybe it's a resident. Maybe it's a nurse. Someone who I don't have to be confrontational with, because I don't want to be confrontational unless I have to be. And if I have to be, I will tell the jury in my opening speech that part of this process is cross-examination. And the first witness I'm going to call is Dr. So-and-so. And Dr. So-and-so is the defendant. And I, by necessity and by the rules of this court, must be able to cross-examine him. And that will mean asking him tough questions and maybe even what you will envision as being difficult. But that's part of the process. So I educate them so they know that I'm not going to be a bad person. I'm going to be someone who follows the process. Conversely, if I have a weak expert, someone who I'm really not sure about and who I have to put on, I will say something like, and I hope I'm not far afield, but I will say something like, part of the court rules, members of the jury, requires an expert witness to come in and offer expert testimony in this case. Now, I happen to have Dr. So-and-so, and he's going to fulfill that requirement here, you see, and we're all going to get through this together, but don't take it all that seriously because the case is really a case. So it's a matter of how you work the problem. It's a matter of how to work the problem.
Gotcha. In addition to sincerity, let me just talk about mechanics for a second. You also talked about preparedness and preparation. And I should tell everybody, I told you in the beginning that, Tom really wasn't allowed to prepare. And as I'm coming at him with these questions, he's not sure where I'm going to go. But there was really hardly any preparation on his part, which I think, Tom, would probably be out of your comfort zone, because it's fair to say that you're a preparation freak.
I believe in preparation.
Let me stop you right there, because I'm going to tell a story real quick. In putting together this program, I was working with Margaret from Tom's office, and Margaret and I talked about what we're going to do. And you're going to see we're going to be putting some stuff up on the screen. And Tom really wasn't allowed to prepare, but Tom really couldn't help himself because he kept calling and he wanted to make sure that the room was just right for you guys so that you could see the screens, this curtain, all this stuff is Tom Kline, all of this stuff that you're seeing. And it amazed me about him because even as I'm doing the course with him, I'm learning something about him. This course is not his responsibility. This course is my responsibility. So the makeup, the room, all the mechanics here are my thing. But what I learned from him was very important because we're doing this program for you. So you need to be able to see us, hear us, appreciate everything, all of the visual things and all the auditory things that you're experiencing. He was very concerned about, which told me that you do the same thing, Tom, that's my setup for you, in the courtroom. I mean, how important is it for you when you go into a courtroom that you've never seen before, that you've never been to before? What's your preparation for trying a case in that setting?
Well, the first thing I would do is confess that as of 5 of 9, I had certain complaints about whether the sight lines were correct.
I was going to say that. Tom was in the back of the room and he was looking, said, they can't see us. He was super fussy, which I loved.
I do the same thing in a courtroom. In the old days, we didn't project things onto a screen. We used, quote, blow-ups. Being ready for trial meant that your legal assistant had the, quote, blow-ups ready. In fact, we had 2 sizes of blow-ups, at least in our lexicon. We had regular size enlargements, which were 24 by 36. And then if it's something that I wanted the jury really to see, and I'll get to answer the full question, I promise. We used to have double enlarged blow-ups. My view of that was the jury would see this is double the size. Mr. Kline must think it's double important, which it usually was. In fact, it always was. That would be the whole purpose. And we used to call them, now it needs a little thought process here, but we used to call them in our office BMFs.
Go ahead.
Do you get it?
Yeah, I do.
Okay.
Just want to hear you say it.
No, if you can't get it, you're not entitled to be in on the joke.
Okay.
I would, in those days, when I learned to try a case, I would go to the place that the furthest juror sits and where the alternate juror would sit. I would ask the court officer, where's the alternate going to sit? Because the alternate is 2 sneezes away from being on the panel. And I would make sure that you could read what you could see. We still make that mistake today. And in fact, today when we were preparing, there are certain things that I looked over in a list of things, and I said that can't be seen from from the back of the room. If you want to present information to someone in a written form, the first objective is to have them be able to see it. So I'm very sensitive to the logistics of it. First thing I want to know when I go in the courtroom. Well, the first thing I learned was that in Lehigh County, you don't sit next to the jury. I learned that the hard way. I was told by a court officer as a very young lawyer, the first year that I was trying a case, young man, you sit over here, not next to the jury. And I said, oh, no, like, even I know that I sit next to the jury. Well, I learned that wasn't true. So you want to know where you sit. But once you know where you sit, the most important thing is where am I going to examine the witness from? And how is the jury going to see me? Like, are they going to see the back of my head the entire time? That's what I was worried about here today. I'm thinking to myself, we have a logistical room here, and I know that I'm looking at you, and I'm having a conversation. I have to have a conversation with you, and you and I have both occasionally done commentary on TV, and we know that it's awkward when you're asked to have someone interview you, but you know the camera's there. And so you're looking out here the whole time. It's very awkward to have that conversation. Well, that same thing is true in a courtroom. And so before you're going to talk to someone, you're going to want to know where you're going to sit and where you're going to speak from and how are they going to see you. And my view is, and this is an age thing, I think, and the older you get, the more I think that you think like this, the less it's, quote, about me. And so if I could give you the old man lesson in this whole thing, in my view, it's that think about what the other people are thinking about and saying, not what you are perceiving. You're not there to entertain yourself. And you're not there to feel good about yourself. You're there to convince someone else, in this case 12 other people, that you're right. That's really what you're there to do. Anecdote, which is a story that I've always loved. I tried a case in 1983, I believe was the year. It might have been 84. And the case involved a child who, as a neonate, lost the tip of his pinky finger. It shows you the case as I was trying then. And the case was a pretty good liability case. If they put a bandage over your hand in the nursery and they snip the tip of your finger off, I think I could probably convince everyone in this room that it shouldn't happen. And the defense was, oh, this was such a tiny little baby. It was, a neonate, and, this is a very tough job. Of course, the controversy was over value between me and the defendant hospital over what should be paid for this. And the jury awarded a nice sum. And it was okay in my view. It was, as we would use in our lexicon, it was a double for the case, not a home run and certainly not a grand slam. And no sooner did I get back to my office, having left the courtroom kind of like this, got back to my office and the phone rang and it was a trial judge. And he said to me, apropos of my discussion that I was having with you, Ken, he said to me, you know what the problem with you is, Tom? And I said, what, Your Honor? He said, you have this great tendency to believe your own bullshit. And I mean, there was a lesson. There was a lesson to be learned there, a big lesson. The corollary lesson to that was told to me one day when I came back from the Beasley office in the same era, 1982, 83, 84. I was trying a lot of cases and learning a lot, and I lost the case. It was, by anyone in this room's description, a dog. I think we all still use that expression. It's not pejorative to anything other than canines. And I came back, head down, having thought that I gave a great speech, again, about me. And the fellow who occupied the next office, Shane Inspector, said to me, he said, the case was a piece of shit. And the case is about the facts of the case, not about you. It's not a referendum on you. But when we're young lawyers, we believe it is. We truly believe that it's a referendum on our ability to convince someone of something that's just not in the cards. And if those lessons could be learned by anyone or translated to anyone out there who's under the age of 63, then I welcome you to take it.
Well, that brings up a question when you say, believing in your own bullshit. Have you ever tried a case that you didn't believe in?
Not one that I told myself I didn't believe in.
Well, that's the reason I asked the question, because it's important for us to actually believe in our case, even if we are believing in our own bullshit. Do you think that's true?
I think what happens is that we recognize, we look at the problems in the case as just that, problems and obstacles, and we don't make a purely intellectual evaluation, because part of the advocacy process is for us to advocate. And therefore, we make a decision when we commit to the case to believe in it. There are those cases, and there are those times, and there are ethical rules, obviously, which govern, where when we can't believe in the case anymore, we can't try the case, and we can't maintain the case. Have I had those situations? Yes. But have I been in a courtroom and tried a case where I didn't believe that the case was right? I'd like to think not. Have there been cases which I believe that the cause was not righteous? Different standard, different thing, maybe.
Okay. Let me ask you this. You're on trial November 15th. I use that as a premise. And all the work's done. You got a trial date November 15th. When does Tom Kline start preparing for that case? And give me some idea of what the run-up is from now in June until November, until the day you walk into the courtroom.
A lot of people in this room who know the truth. November 14th.
Is that right?
Maybe the 13th. If you read a terrific book, which is a story of two cases that Shannon and I handled, one being the Hall versus SEPTA case, which many people are familiar with because we did what I think is some real good in that case in changing the legal department and the way claims are handled at SEPTA. We literally reinvented and changed the escalator system, and a case that Shannon had, which he litigated not only in the courtroom but in the CPSC involving a Daisy BB gun. In that book, which was written by Bob Zausner, who's a former Inquirer reporter, Bob had the same charge, by the way. Oh, look at that, the ad is up.
Things are going to start coming up now, Tom.
Wow, we found something. But that, in that book, you will learn, and I tell this when people come and interview, that if you want someone who's prepared for months and on your case and is going to go to bed every night and get 8 hours sleep and not have anything, hire Shannon. Me, you will learn it's what I'd like to think is full, complete preparation, but I like to do it for a couple of reasons at the end. I can learn, this is confession, I feel like your father confessor here, but a true confession is I can learn most what I consider routine, uncomplicated medical malpractice files, which are prepared by some extraordinarily skilled people who we're lucky to practice law with in our office in a few days. And I can learn a complicated file in a week or 10 days or 2 weeks. I was given the first very substantial jury verdict that I had was back in 1983 when Jim Beasley handed me a Dalcon Shield file. It was in the infancy of mass torts. It was in the infancy of the really development of mass tort law, well before the Daubert case, which was a Bendectin case, which is a case that I also tried. There were only 3 or 4 lawyers in the country who tried those cases. But what I learned in the Dalcon Shield case was about 7 days before trial, I was given this massive, massive file, which was developed in an MDL, which had hundreds of thousands of documents, tens of thousands of papers, hundreds of witnesses. And I was told by Jim that defendant is offering $80,000 and the demand is $140, and quote, we have to try the case. There's a couple of lessons in there, by the way, one of which is that your demand should be meaningful. When you ask for something, you should have some reasonable basis for it. And we were going to try the case. The problem was the we was me. And I learned that I could get through the material. But in my view, it's not the time that it takes. It's making sure that you've actually done the preparation. I never go into a courtroom unless I know that I'm fully prepared. And anyone who's tried a case along with me, I think I would like to hope, and I think would say that's correct.
When do you put that opening together? The night before?
No, I mean well, yes, sometimes, but I like it fresh. I'm not somebody who can put together an opening speech 3 weeks ahead, put it on the shelf. And frankly, I'm able to do it, and I'm also in a position of truly luxury of having people who work along with me, many of whom are equally capable of going to the courtroom and giving that speech. I have a system that I like for what it's worth. Regardless of whether I'm going to follow it to the T, along with, and I do it along with, as a general proposition, the lawyer or lawyers who are working on a file with me, I will sit down and I will do an opening speech that includes concept by concept, page by page, module by module, the opening speech. I will then insert into it every key document. And the key document needs to be matched up to the Bates number presentation number, so that when I'm done, I have something that's literally almost always this thick, sometimes this thick, and it will be the whole roadmap to the case. And I'll find during witnesses, I'll be able to go for the document. While I'd like to think that I'm plenty tech savvy and know how to use technology very well in the courtroom, the fundamental of having the stuff on paper is key. It's almost always in my hand notes, and I will sit for hours and hours and hours and hours with the lawyers, sometime over the weekend, sometimes not on their schedule, sometimes all day, all night Saturday, and all day, all night Sunday. It's not unheard of that I'll, before an opening statement on a Monday morning, because that's how we do it. And of course, in Philadelphia, everyone in this room knows we pick a jury Friday. We open usually on Monday. And I will, sometimes on that weekend, have worked 30 hours, 35 hours, sleep very little, and put the case together, if it's in that manageable period. But trust me, if the case needed 2 weeks to do that, I would do that. We are about to, I'm about to in October, try what will likely be the first denture cream case. We have a number of people who we represent, well over 100 folks who have neurologic, some devastating neurological injuries caused by the use of polygrip and Fixodent. Unbeknownst to them, and unbeknownst to them because they sure weren't warned about it, that over-the-counter product contained zinc. Zinc is a heavy metal. I plan to say it in that way in an opening speech to a jury. A heavy metal, which caused them neurologic damage. That case is currently in the throes of massive discovery, which is being conducted by our office, and expert reports are currently being prepared. And trust me, I will not try to learn that in a weekend. I will spend weeks getting ready for that, like I did in the Bendectin litigation, like I did in the Vioxx litigation. It's not only trials. In the Vioxx litigation, our office was charged with the responsibility of interviewing, I shouldn't say interviewing, deposing many of the, in fact, nearly all of the key Merck personnel, their lead scientists, the face of Merck, the CEO and the like. And those were each a preparation for a trial. And those took sometimes weeks to prepare. Weeks of coming into the office every day, sitting down, learning the most complicated science, at least in my view, and learning not how to present it to a jury, whole different task, learning how to deconstruct what was a party line, and doing it in a way which would end up being effective in front of a jury. Sometimes the goal wasn't to present it to a jury, it was to eliminate a witness who we knew were going to call and we thought would be effective.
In doing that, and you talked about presentation a little bit, are you more high-tech, low-tech, or are you a hybrid? Are you using a lot of the video stuff? Are you using the boards? I mean, how exactly, what's your breakdown in terms of how you present it to a jury?
All high-tech, all with a proficiency and a way that will easily convey the information. But there's a balance that has to be struck. And there are certain things that are much easier to do with an Elmo than to do with a fancy board. And I've been there where and I know there's a lot of litigation support people in and around our midst here, but it's fundamental that you're able to call out a document and it comes up. Fundamental. Jurors roll their eyes, they're impatient generally, they're used to instant success, they're used to not having flaws, and they're born and raised in the TV age. I have a whole theory. Your question doesn't call for it, but it seems like I'm allowed to talk since it's a conversation. And I have a theory about use of TV in the courtroom, use of technology in the courtroom. I have this process where in the introduction of my injured plaintiff, almost always I stage it. If I have someone who's catastrophically injured, perhaps in a wheelchair, perhaps brain damage, perhaps a child who's severely brain injured, I have a staged process that I believe works. I believe that we live in an age, and I have no justification for this and no scientific studies to prove it other than it's Tom Kline's theory, which is that the way to stage it is to have the jury not see your client in opening, not see your client during jury selection. Sometimes the defendants ask for it, but rarely. I will show a photo. I will then have the jury see the individual on the screen, on the TV screen. I believe that that raises anyone who's been seen for the first time on a TV screen to a celebrity status, if you will, of sorts, if you will. And then, for a limited, brief period of time, I'll bring the individual into the courtroom, usually with a rehab person. I'm sure you've done the same, Ken. And I will stage it so that there's a limited exposure to the client. I think that's enough. I think it's appropriate. I don't believe that you can just pull sympathy strings. And I think if you're overdone, you've deleted the reservoir. And juries know it. They know when they're being worked. They know when they're being gamed. If 12 of them don't know it, 3 of them will. If 3 of them know it, 1 of them will say it. You're working with a group. Therefore, you're working with a group mentality. Therefore, you're working with a group philosophy. So the key in the core, in my view, and this is, quote, use of technology, is to use technology for a very instrumental purpose, which is to introduce my client in a visual way that is disconnected to the person, and then they see, oh my God, this is a real person. Look at this. This is that person who we met.
Got it. Okay to get personal now?
Sure.
Okay. All of us in this room come from different backgrounds, and I wanted to talk about that a little bit. I mean, I grew up in North Jersey, and I have a blue-collar background myself, and you know, I use that sometimes to my advantage in a courtroom. I'm wondering, first of all, from you, how important you think background is in terms of our own personal background when we present a case to a jury, and then maybe tailspin into Tom. Tell us a little bit about your background.
Well, first, I'd be remiss in not saying, no, we'll get there. I'd be remiss in not, if I didn't say that there's a great clip on YouTube. If you punch up Ken Rothweiler, the other night, Ken, who does a whole bunch of Fox commentary, does a piece on, I think it's called Talk Back, about his son, who is now 20, and Ken talks about living the dream and thinking about being about something like a trial lawyer. It's a great piece, and all you got to do is go to YouTube and punch it up, and it's really terrific. It was on just the other night.
That was an unrehearsed commercial, by the way.
No, it's fantastic. But but Ken in that piece talks about background, and he talks about you know. Where you've been and where you're going, I guess, is in terms of talking to his son. And I believe that we, no matter where we came from, should never forget where we came from. There's a great article, great obituary in the New York Times on Michael Bloomberg's mother, Charlotte, who lived to the age of 102. And in the obituary, Bloomberg affectionately mentions 2 things about his mom, which are kind of neat among many. And this was a woman who lives in Medford, who Bloomberg would go to Medford to see, who didn't want the fancy castle that everybody else in the family apparently took. When he said, you know, would you like the mansion? Sure. Would you like the mansion, Mom? No, thanks. I'm happy right where I am. And a lot about the obituary talked about a very successful man and his touchstones, in this case his mother, who, by the way, was asked what was the success of living to 102, what would she attribute longevity? And her answer was, never eat anything that tastes good. But she also gave some pretty good advice. So, I mean, where you're from and your background is part of who you are. And I know this is about being a trial lawyer, and it's a hard thing to psychoanalyze for all of us. But basically, my view of it is you have to try to be yourself, and you have to never forget where you came from, how precious life is, how short it can be. We all know that. How precarious it is. We all in this room know that. And just to be mindful of it.
Now you can put it up, Margaret. So where did you grow up, Tom?
Grew up in a town called Hazleton, PA. Population 25,000 in its time. That's the double house. My dad came back from World War II. He purchased that house like many Army vets did. He was proud of it. He rented out the other two sides. He decided, why have only one income on the other half of the, quote, double? Let's have two incomes, so he carved out two apartments. The lower apartment for many years was rented by a man who worked for Beryllium. And it won't surprise you that he died an early death. And while I might not have connected all of those dots, I certainly knew and understood that he had a toxic injury. My dad died in 1981. My dad was high school educated. He was a great guy, and he was very smart, and I learned very early on that you didn't need either a college education or a master's degree or a PhD or, God forbid, a law degree to be really smart and really successful and really loving and really caring. And he died in 1981. He died of a rare bone disorder. And it wasn't until way in the, just about 2 or 3 years ago, when there was a lot of publicity really uncovered by the Inquirer about how exactly where he was he managed a dress factory. He was a dress factory manager, and it was right on top of a toxic waste dump. So I know what happened to him too. And in fact, there it is. It was pulled up by Margaret, and I didn't put those pieces together till way later. But I grew up in that town. There was a vibrant yet small Jewish community, which was there were 2 synagogues. There were a lot of immigrants. My grandfather came to the town in the very early 1900s and was a peddler, and eventually had a men's clothing store. And it was an ethnic town. I tell people from Philadelphia it would be like growing up in Roxborough if Roxborough were a standalone city, which it thinks it is.
Did you feel like a minority being a Jewish kid in Hazleton?
Yes, very much so. And understood it and knew it.
And in terms of that background, Tom, I mean, you know, feeling like a minority in a community and being from a working class environment, is that something that helps you in a courtroom, brings you to, you know, some other perspective when you represent a client and try to explain that to a jury?
Sure. I worked in my dad's factory. I we had anthracite coal up there. I was 10 years old when I took a job filling coal bins. I remember I charged the neighbors $9, and I charged my aunt $13 because my dad told me she could afford it.
Always the businessman, Tom.
And I was very mindful of it. I mean, it's funny because I had a conversation just literally yesterday. I came back from a trip. I walked in the office. I was wearing a suit and tie. And Senator Specter was in the office. He now is on the 19th floor with me and with Shannon. And he said to me, "You're in a suit." And I said, "Of course I'm in a suit. I'm in a suit because I at least actually believed that if I would be able to have a job where every day I got up and put on a white shirt and a suit, that would be a pretty good accomplishment." And you don't forget those things. And I don't.
You told us about your dad a little bit. Tell us about your mom and maybe what you've got from both mom and dad that helps you out in the courtroom.
Well, my dad, I'll start with, was very loyal to my mom. My dad, and I know there's a picture of my dad in the factory, surrounded by 100 women. If it wasn't shown, it should be shown. It's a great photo, and I have it in my office. If we can go back, there it is. And I used to say that my dad had what I think is what could be a better job. I mean,
that was your dad's coworkers?
That was my dad's coworkers.
Right.
Exactly. And the man went home every day for lunch with to see my mom. So that tells you something about my dad. If you go back one photo to my mom, it's my favorite picture of her and how I remember her. Actually, it's snapped by me this morning because I wanted to have it in. There's just so many things going on in there in that photo. But she was terrific. She was kind. She was sensitive. She was loving. She had breast cancer when I was a very young man. And she lived with it all of her life. And she died at age 74. And she was an inspiration.
And those things, Tom, that we live through, like the death of a mom or a dad, did those types of experiences help you? Because the people that you represent have those same types of tragedies in their own life. How do you tap into that to help express that in the courtroom?
We know when we try a case that everyone who sits in judgment of the case as a juror knows and understands and brings those feelings and those emotions with them. I tried a case recently in December. Again, to me it wasn't as much about liability as it was about value. And there's, again, a lot of experienced lawyers in this room, including you, Ken, who know that we get into these fights over what's the case worth. And I tried a case involving the death of a grandmom. She was 72 years old with 2 grown children. And I really only wanted to know one thing from the jury, only one thing, when I questioned in voir dire. I mean, did I want to know other things? Yes. What did I care about? I cared about what their relationship was with the parent. Every juror. That's what I wanted to ask them. So I would ask every juror, is your mom and your dad alive? Yes or no? If not, when did they die? At what age? What was or is your relationship with them? And to me, that would be very telling because, yes, they're to put aside sympathy. Yes, they're to put aside prejudice. Yes, they're to decide the case on the facts and the evidence before them. But they're going to bring their own personal translation to it, just like I bring the translation of my late mom into every presentation I do. I bring the same thing involving my late wife, Paula, into that. It's never forgotten. It's part of you, and it is with every juror. Now, in that case, by the way, I had I can't resist the anecdote. I had one man. I said, "Mom and Pop still alive?" "Yep." I said, how old's Pop? He said, 85. I said, do you see him regularly? He said, I live with him. I thought it was a little odd. He's a man who's 50-some years old. You employed, sir? No, I'm unemployed. You can make your own decisions as to whether you want him on the jury or not as we go along here. I said, okay, how about Mom? How old? He said, well, Mom, and he looked at me kind of like this. He said, well, Mom is 79 or 80. And I said to myself, 79 or 80? Everybody who's, anyone who had any kind of relationship with Mom knows if she had her 80th birthday, like right. something you don't miss. Like your parent just isn't said. Could you say, well, Mom's 81 or 82? Maybe. Right. But I hate to tell you that the pool was so lousy that he was on the jury and looked at us the whole time, like one of those people who looks back at you. And you say, I thought this guy was a nut when I interviewed him, and he still looks like a nut. But my point about in telling the story is that's what I was interested in. That's, to me, the sensitivity had to do with my sensitivity to my relationship with my parents. I know that not everyone is that fortunate.
Okay. Let's talk about you growing up a little bit, Tom, if we could. Were you competitive growing up? Play sports?
I was going to say, I think it depends on what you call competitive. I loved hoops. Everyone who knows me knows that I love basketball. If I had a dream, it was to be a point guard in the NBA. But 6'3" Jewish kids.
You would have never made it. You would have never made it, Tom.
Don't make it. That's not a guy who's going to make it into the NBA. But was I competitive? I came home from a JV basketball game and complained to my dad about not having enough playing time and about the referee's calls when I did get my playing time. And he reminded me that, true story, there's a lot of true stories. He reminded me that I was neither going to have the job of coach or referee. And so maybe I should just focus on academics, which I did. Kind of a corollary to that story of advice, which was good advice that Dad gave me. I came home from 7th grade shop class. I had built a funnel, which I still have in my office. We all have, I don't know how many out here have actually had to take sheet metal. It kind of distinguishes, at least Penn Charter, from the H.F. Greeby Elementary School, or junior high school. And we took shop class. I viewed shop class as a place that was a future, that it was a training ground for how you would survive in prison. Because a lot of the kids, because the shop teacher would go out for a smoke, the place would be like a prison shop. We didn't call them bullies at the time, but the bullies would come in and shake the other kids down for money. And a lot of my classmates ended up in prison. So I guess it was good that they got some exposure. But I brought very proudly home this funnel. And I handed it to my dad with some pride, having, by the way, had woodworking the year before. Now we're in sheet metal. I've advanced to sheet metal. And he looked at the funnel, and he said, I want you to pay particular attention to the welding and the detail and the craftsmanship in that funnel. And he said to me, you will be better off making your living with your head, not your hands. And
I think he was right.
It's true. I took his advice.
Now, does it serve us to be competitive, though, as trial lawyers? Is that a good quality, do you think, for those that are very competitive, or is that something that you think is not all that important?
I'm going to say something that's both what I really believe, obviously, and the way that I looked at it. I never looked at it competitively. I know people do. I know we live in an era of competitiveness and rankings, and everybody's worried about, you know, how everyone else views them, and we look at it in terms of marketing and things that didn't exist in 1980 when I entered the practice of law. When I entered the practice of law, I saw one thing which made a lot of sense to me, a lot of sense, which was if you went out and you tried cases, you would develop a reputation, and if you did it well and you were successful, you would attract clients. And that was Jim Beasley's formula. It was no more complicated than that. And I've lived by it. And to this day, that's what I've decided was the best way to go about it. And I don't consider myself the best at schmoozing or at many of the things that may be a good idea. I've just decided that a trial listing every couple of weeks, literally, would be a good formula for a law practice. And I've lived by it. If that's competitive, then I'm competitive. But I've looked at it, I do a lot of competing against myself, do a lot of kidding with Shane and other lawyers in our office who are enormously successful and have a ton of very large verdicts as to who has the most of this and who has the most of that. But that all gets lost in the shuffle.
It's interesting that you mentioned Jim Beasley because, I mean, you were trained by Beasley. I was trained by Herb Colesby, and that's one thing Colesby always told me. He said, you want to be a trial lawyer? Go try cases.
Be a trial lawyer.
Yeah, go try cases.
And people know that. People know and understand it. And by the way, in the world, this is a candid conversation which I will continue to have with you. And in the world of competition for cases, where we all know of the quote beauty contests where you know you're being interviewed and other folks are being interviewed, I just tell people that I believe that the measuring rod for success in handling the case, a very important measuring rod is the trial record of the lawyer. And of course you have to try cases to get that record. But it doesn't have to do with that much else. Yes, achieving a good and important settlement is something that's important. But at the end of the day, that's, I think, what being a trial lawyer is about, is going to court. People often say to me, what are you? And I know we're proud. We say we are trial lawyers. And that, by the way, that term has a political implication to it as well. But sometimes I go further and I say, someone asked me, actually, I was away on a trip and somebody said to me, are you are you like a real lawyer? And I said, I'm a courtroom lawyer. I actually go to court. And that's the dividing place for a lot of us.
Gotcha. Let me go back to a second. You had said that, your favorite sport is hoops, and I know you're a big Sixers fan. I see you at the Sixers game.
That's only if we're not in baseball season.
I understand that. I'm going to get to that for a second. But there's another sport you liked as well that you did when you were younger. Am I correct? You remember some of the sports you liked when, as I went through some of your memorabilia, I saw some action photos of you.
Oh, but you mean, yeah, you're trying to prompt me?
Well, a little bit.
I was a bowler. You wouldn't think it, but I bowled in a league. My mom bowled in a league and had a room full of trophies. But
is that you, Tom? Is that
that's me. Look at that form.
That's got great form.
And
fabulous.
no, I bowled and I was pretty good. I mean, it's a non-contact sport.
Right.
And my view of it is that's Father's Day 2 years ago at the Thunderbird Lane, Manahawkin, New Jersey. And same form. But yeah, I love to bowl. I love to bowl then, love to bowl now. And there's something about knocking down the pins. Now, I love to play squash. You have literally a to-be pro squash son who is ranked number 5 in the country. Like, that's really something to be proud of. Now, I play squash, too. I am ranked somewhere in the D class, and but love to play. And there's something about bowling and squash that have the same consistency, which is you can throw the bowling ball or hit the ball as hard as you can, and there's something about taking out aggressions. Angry Birds on the iPad. If you're not an Angry Birds person, how many are Angry Birds people here? Look at that. Get with it. Angry Birds is where it is in that. In fact, I like to have my iPad, since it's permissible now in the courtroom. I like the iPad. I have two things that I usually play during the I hate to say this, during the charge to the jury. And now you know this one. One is there's a great bowling game called 300 Bowl on the iPad. You just click away. And the other is Angry Birds, because you know it's being set up there as long as you're listening. As long as you're listening with one ear.
Let me ask you this. I know you love music, and I'm just wondering what part music plays, and what I'm talking about specifically are songs. What influences that they have on you, or have you used them in a courtroom? I know you're a big Dylan fan, correct? You've been to how many Dylan concerts?
Over 100.
Over 100. And a lot of the stuff that Dylan writes is pretty heavy stuff. I mean, do you use any of that in a courtroom? Do you quote things like songs or poetry or quotations?
Unlike, first of all, I just attended a forum at Fordham University entitled Bob Dylan and the Law. And in the advertisement category, I'm in the process of just the initial stages of preparing with my son, Zach, who's in the room. And stand up, Zach. You're like the guy. And we're preparing a seminar. Zach is a 3L at Drexel Law, and we're preparing a seminar which will be in November, likely at the Wilma, entitled Dylan and the Law. And I say that in response to your question, first of all, to work it in, and secondly, we're going to get Pat to sponsor it, so that'll be hopefully work out. But Dylan has kind of an interesting view of the law and judges, which is largely negative and largely pejorative. He talks about the hanging judge and the judge who is drunk, and a lot of pejorative terms, and has a very critical view of the justice system, especially the criminal justice system, all of which more to come, anyone who shows up in November. But having said that, there's a lot of things that I do. I try to work things into the closing, if for no other reason than to amuse or interest myself. So I will find something. Sometimes it's arcane. Sometimes it's not what is usually quoted in the law. Like when Justice Scalia quotes Bob Dylan, he quotes in a recent opinion, I think it's Scalia, quote, "The times are a-changin'." And for a true Dylan aficionado,
Right. Not so good.
Not so good. But if he thinks it's happy and it makes him hip and culturally literate, then I guess that'd be good. But sure, I mean, it's fun to take what you like and convert it. Shane Inspector quotes Churchill. I quote Dylan. But I like to work it in. I sometimes do things. I believe that we take ourselves too seriously. So I sometimes will do things for a variety of reasons that don't have a direct impact on the jury. I'm doing it for a different reason. Sometimes I'm doing it for what I'd refer to as a bank shot. It's not a direct shot, it's a bank shot. But sometimes I'm doing it for a collateral reason. I can remember a case tried many years ago, tried it in, it was very hard fought. It was a heart transplant case that involved a very prominent surgeon at a very prominent institution who was very well known and developed a procedure on correction of children's hearts. And he had trained and developed it at Boston Children's, follow the story, and he had then been a fixture and a dominating force at Children's Hospital here, and eventually ended up at DuPont after a stint in Switzerland and many lawsuits. And I remember asking him on the stand, nothing about Bob Dylan, but I remembered asking him on the stand whether, and it was a while ago because there was no Acela train, there was a Metroliner, and I asked him if his career, he believed, resembled a ride on the Metroliner. And he said he didn't understand the question, which he didn't understand most of my questions for some reason. And I said, you know, all south. Boston, Philly thing. And just like everybody in this room, you're nonplussed by it. I was amused by it. And he was irritated by it. And my intention was to irritate him. And my intention was to show that he was arrogant and to show that he was pompous. And I remember the trial judge, very experienced trial judge, saying to me afterwards at a break that he, quote, didn't think the jury got it. And I said to him, I didn't intend for the jury to get it. Didn't intend that at all. So you're not doing everything all times for the single purpose. It's a very multi-dimensional thing we do in the courtroom, very. And there are a lot of moving parts and a lot of moving dimensions. It's not a two-plane surface. It's 3D.
The reason I asked you the question, I try cases with my partner Dan, and he always kids me because I always use movie references. It's a Wonderful Life is probably one of my favorite movies, and it's an example of how one person can change just everything in other people's lives. The movie Rudy, which shows persistence and shows somebody going after something and not giving up and going after it and finally succeeding. And I always try to, in some way, work those in because I'm a movie buff. They mean something in my life, and I try to translate that to the jury. And I know because you're a big, music guy that, how you would use that as well.
I view music as playing a different role in my life. I view it, we all as lawyers live a very pressured and in some ways more difficult existence than a lot of other people. And we need music more than other people. Music is a great way to relax. And I'm just not about Bob Dylan. There are a lot of there's a lot of great music that you can have, and a lot of great music you can share. My friend Richard A. Sprague is here today, and I introduced him to Leonard Cohen, the great poet laureate of not Dick, but the great poet laureate of Canada. And Cohen just has this wonderful, deep, meaningful music, and I look to that. There's a photo. I always say that for $1,000 you can get your picture taken with almost any politician, but you can't. But you have to wait in Montreal outside of the stage door to get your picture taken with Leonard Cohen, age 75, still touring the world, and having written some great stuff. I just was fortunate enough. Zach and I and my daughter Hillary and her husband and my granddaughter went to Greece, but Zach and I took a little side trip to a little island called Hydra, where there is, as I like to say, high-speed internet, but no vehicles, so that you get to your hotel room from the port when you get off the boat on a mule, which reminds you of a lot of things. Like it reminds you instantly of how different life can be. And Leonard Cohen, who's pictured there in Montreal about 2 years ago, wrote a song. Actually, he conceived the song there. I want to make sure that I'm accurate. He conceived the song, didn't write it, called Bird on a Wire. And I was at sunset just a few days ago on this island of Hydra, where, there it is, where I snapped that photo. And to me, it's a sight of beauty. Great, there's a little port town. I know it's 5,000 miles away, but it might as well be 1,000,000 miles away from what we do and where we live and how we think that this is the epicenter of the universe. And it's not. It's not at all. And another thing that you haven't asked, and I actually don't think you and I discussed it, but I have over the years collected antiquities. If you come into my office, I have a number of ancient mosaics, which I've collected and are on the wall. And I marvel at them, touch them almost every day. Here are things that you can touch that were built by someone with a craft, like us, in 400 AD, 1,700 or so years ago, and they still exist. And to me, it tells me every day that I am not the center of the universe, that this is not the, we're just passing through.
Yeah, I agree. Getting back to music for a second, I'm sure that because you love music, you probably played a cool instrument like the sax. Is that?
This is a must for the interview. I was in Rosebud's all accordion band.
All accordion band.
Right. Now,
So you bowled and you played the accordion.
Yep.
We're getting a visual picture here.
I did. I know. I know. There's other people who've painted different pictures of me, but that's it. That's in the backyard, and Rosebud had an all accordion band. I played in moose clubs, Polish weddings. None of the Jewish weddings had accordion bands. I was not a mummer. This was an accordion band, and again, now to tell you just how good I was. In an accordion band, there's first accordion, second accordion, third accordion. Third accordion boils down to, well, first accordion means you're going to play like both the melody, the whole thing. Like the second, you have some proficiency. Third accordion, they have you play the chords along with everybody else because you can't screw it up too badly. I was third accordion.
Looking really cool there, Tom.
Another reason to become a trial lawyer. I don't know quite what the patch is, and I don't remember the patch. I have that accordion. That accordion just celebrated its 50th birthday, and I actually have it displayed at home in my library.
Just one more question.
And by the way, this is in the if you want a translation, when I tried Hall versus SEPTA, I asked the jury. And I no preparation. And the thought struck me as I was giving the closing speech, literally, in my head, not having, no premeditation, I said to myself, in these 3 weeks, the one thing, this was such a good mom. She bought a $65 pair of shoes for her little boy. I mean, this was a mom who went out and took 2 SEPTA modes of transportation, the subway and then a bus, to get to her job at something the equivalent of a dollar store, and then to come back to North Philly every day. Yet she purchased this $65 pair of shoes. And when I went to the jury, the thought struck me, and I said, say it, Tom. Little bird, in the back of your head. And I said to the jury, whatever you award to this family, and by the way, I literally thought the glass was totally full. I thought we were doing okay. I said, whatever you award, would you please give Mom the $65 that she spent to buy this boy's shoes out of her pocket when she every day scrimped and saved to put food on the table and to raise these 2 boys that she was raising. Whatever you do, award the $65. And kind of apropos of that, and I'll get to the story, the accordion, that accordion was purchased in 1957. It was mother of pearl, because I think they thought that I was going to be an accordion player, because I sure as hell wasn't going to become a basketball player. And it was the price tag. When I looked recently in the box, actually I took it out of the box to display it in a library, and the price tag was still on it. It was, I think, $375, which was a lot of money, and it was the functional equivalent, if I can draw a parallel, of Sharif Hall's mom buying those $65 shoes. And the jury gave us the $65.
What was the verdict in that case, Tom?
That number at the end, very end of the verdict said, and 65. It was a lot of money.
What was the total verdict?
It was something larger than large.
It was $50 million and $65 or something, wasn't it?
Something like that,
Something like that. All right, thanks. We're going to continue this conversation with Tom Kline, but I want you guys to go and relax for a little bit, take a break for 15 minutes, and we'll come back and conclude. Thanks. During the break, I was talking to some of my partners, and they were just a little bit amazed because they've never heard me ask questions and be so nice in asking the questions. I said, like, where's the Rottweiler that we really know that just asks questions and grills somebody and goes after somebody, because, you know, that's what we do for a living. So,
Is that what the second half is
well,
about?
we're going to change this course, right. We're going to change it from a conversation with Tom Kline to a confrontation with Tom Kline. Well, and, you know, I was thinking...
That would go over again. You could try
see.
it. I'm going to remain the same calm,
All right.
relaxed, easygoing
You do it.
demeanor. You're not going to get me.
All right. Well,
Have you ever been a witness? See, I get
once.
to turn it on him now. Yeah, that's not as much fun as asking the questions.
No, that's true.
That's another thing, that every trial lawyer should at some point be a witness. That would be a good thing.
No, you're right. That is a good experience. Well, let me ask you this, and then this is something I just thought of on the break. I've been to your place at Liberty, too, and I know you have a place down at LBI, and you're obviously a very, very successful guy. You've had a marvelous career. You've had verdicts that are just outstanding, and we'll talk about some. You've had some of the biggest verdicts in the state and some of the biggest verdicts in the country. But what gets you out of bed every day, Tom, to keep going, to keep trying cases?
Nothing else to do?
I guess you can't go back to that accordion.
I can't play the accordion. I don't want to. I thought I wanted to be an NBA coach when the point guard thing failed. I don't want that anymore. Charlie Manuel has the Phillies, and I like what I do, and renewed the lease. So that means a commitment. But I like what I do. I think, and it may sound trite. I'm trying my best not to say anything trite, but it may sound trite, but we do a noble thing when we get up in the morning. We represent people who need us, and we fight against a lot of odds. I think maybe characteristic of how I really feel about it is I've taken to telling prospective clients, for better or worse, when Shannon hears this, he's not going to like it, but I tell them, for better or worse, that I don't have to do this, but I'm doing it, and I think you should consider that I want to take your case, and I'm willing to take your case, and I'm willing to do what's necessary to see that justice is done, because I want to do it. So if I commit to you, I'm going to do it, and I'm going to do it because I want to do it, not because I have to do it. It's a great luxury that is worth working for.
Yeah, because what always has amazed me is, you know, your mentor, Jim Beasley, did it basically to the day he died, and Mr. Sprague is here, and, you know, he stays active, and you do the same, and it always amazed me that, you know, the great trial lawyers just keep on doing it.
Well, I can tell you that I recently saw the great Richard A. Sprague, and he is truly a legendary lawyer who's sitting in this room here, the great lawyer of the past half century, in my view. And Dick, who both has sued me and who's represented me.
Kind of a mixed bag there, I guess.
That's why he gets up in the morning. But I saw him cross-examine somebody recently, and I think you make a judgment on these things as to what you want to do in the morning. And Dick, who is my elder, and who in Sprague versus Inquirer won the first time the case was tried in 1983. My two bosses in the case, since the client is really your boss, my two bosses in the case were Dick Sprague and Jim Beasley. And I used to say that, number one, I say that was the real Beasley School of Law, where I graduated. And I can remember in those days, I'm going to tell a story just to embarrass Dick, because I want to tell the story, and since I have the microphone, which is Dick used to give me all good ideas. I learned a lot during that first trial from Dick Sprague. Dick used to give me good ideas, but Dick knew that if he proposed them to Jim and they weren't Jim's ideas, that they were undoubtedly not going to succeed. They're not going to become the rule of law, so to speak. And so he used to give me these great ideas, which I, as a third-year associate, would come up with and tell Jim, and Jim would like them from me. He would think they were good ideas. He would say, "That's pretty good. This kid's pretty smart." And we tried Sprague versus the Inquirer 1, which became a landmark case in libel law, which ended up being retried. It was tried the first time for God knows how many weeks. It seemed like forever. I just remember the meals that we had every night down at that fancy restaurant that was on the waterfront, the name of which escapes me. It's no longer open. I'll find out later. And I think you have to make that decision. It's a decision that all of us face as trial lawyers. At some point, we say, okay, I've been successful. I'm doing this a long time. John Edwards, to mention a name of somebody who you and I both know. People talk about John in the past tense often. They say somebody who I knew, but somebody who we know was decided at age 40-some that he didn't want to be a trial lawyer anymore. And Jim Beasley at age 76 didn't know he was ill, didn't know that he had metastatic cancer, was trying a case in City Hall. I remember because I rode up the elevator with Jim, and he complained about the rulings by the trial judge, so I knew he was still active and vibrant. And I think you make those decisions individually, but there should be no ceiling on it.
Well, let me answer something, because it's been my observation that the people that I know that are great trial lawyers, both in Philadelphia and around the state, I would say that, from my observation, the greater majority of them have been trained by great trial lawyers. And just like your perspective on it, if I looked at the Beasley office, the old Beasley office, a lot of great trial lawyers came out of that office. The Litvin office here in town, a lot of great trial lawyers. Raines's office, take my own example, the Colesby office. And I don't think it's an accident that great trial lawyers are trained by great trial lawyers, because it occurs to me that, no one just has the innate ability to be great. I think people have to have a certain amount of talent and then be taught how to maximize that talent. What's your take on that?
My take on it is that you do an awful lot of learning by observing, and that includes good habits and bad habits, good practice and bad practice. And I counsel law students, I counsel young lawyers often that the best thing that they could do is to be in practice with a good mentor, with somebody who's a good lawyer. I was fortunate. I came into the practice in January of 1980. I accepted the job a little before that. I remember being asked when I was available, and I said January 1st, and Beasley told me he didn't expect me to work on New Year's Day. So I started January 2nd, and and I was fortunate because I had a mentor, and I see a lot of young faces out here, and one of the things that I just can't strongly enough suggest is that you be in a position not only to be able to eventually be in a courtroom, but equally important that you have a good and a strong mentor. And it's just no accident that it's developed that way. The art of trying cases, it's very interesting as I've seen it progress in the 32 years now that I've been practicing law. There's been a lot of development, an excessive development in my view, on the formalistic training of lawyers on trying cases. Not necessarily in law school, although there's been some of that, but in LLM programs and in seminars and the like. It's not exactly you can't teach it all. You can't teach good judgment, for example. Some people will not have good judgment when they're 75, just like they didn't when they were 25. But there are a lot of things that you can learn from watching and absorbing from a good mentor, and it's just no accident, and it's something that's worth considering if a lawyer's in a position where he or she thinks they should have some better tutelage.
Right. Let me ask you about...
And a lot I might add, if I can add something
Yeah,
that
sure.
I can. My view of it is that a lot is by you learn by seeing. You don't necessarily learn by the didactic of saying, okay, now this is how you handle a witness. That's very important, extremely important to have that. But it's equally important to see, and I think more important, to see how it was done. I have this CLE developed, and while it has a fancy title called Trial as Theater, and it sounds more drama than it necessarily is, it basically has a single concept, which is for those who want to see things that have actually been done in a courtroom, they can. And then, as I explain it, I believe every one of them, you can take from it what you've seen and either adapt it or use it or not. But you have a good barometer because you've seen things that were actually used and done with some degree of success and hopefully proficiency.
So for those people out there that maybe don't have the ability to maybe learn from a mentor, would it be your suggestion for folks to find their way into a courtroom and watch people that actually are trying cases and seeing how it's done?
Yes, and I often get that kind of call, as I'm sure you do as well, that people will, someone will say, would you tell me? I got an email literally the other day. Next time that you or Mr. Spector are in the courtroom, may I come and watch? It's someone who is, a younger lawyer but active, and she just wanted to do that. And I emailed back and said, Lynn McCluskey, sitting to my left, will keep an eye out for it. It's just fundamental. It's great. The best place you can learn is to go over to City Hall and ask around. And by the way, you can go over there and learn what not to do. There's plenty of what not to do.
Right. I'll just tell you a quick story. The first time that I ever saw anybody advocate in terms of a case, I saw Jim Beasley give the program about the Cessna case. There must have been about 300 people in the audience. I was about 25 rows back. And when he did the closing, it was one of the most unbelievable things that I had ever seen. And it was interesting because when I thought about doing this program, I think in a way, while he's your mentor, in a way, you're kind of the polar opposite than Jim Beasley. Jim Beasley seemed to be, there's something about him, there's a little bit of an anger in him or something about him that drove him. It seems to me that you do it in a different way, but yet you were trained by him.
My belief is that when you have a mentor, you have a really great lawyer. And there's a picture of Jim and me in mid-1980s in Cape Cod. We're both actually walking back from the men's room. I happen to know that. That's where the men's room is. And
thanks for sharing that. I kind of add some depth to the whole thing.
And a much younger me. But, and it's funny because we've mentioned Jim more than a half a dozen times during this seminar, because that's what I think that's what legendary trial lawyers eventually end up talking about them. There's a great line in a very arcane Dylan song called Brownsville Girl where he says, they can talk about me plenty when I'm gone. I ain't got no regrets. But the fact of the matter is that is that Jim and I were different in a lot of ways. Jim told me one day that he thought I was too nice, too gentle. My mom gave me that advice too. She told me that came from her side of the family, not my dad's. And that's just like my new granddaughter. Anyone who has a granddaughter in this room will appreciate this story. I'm always asked the same question. Everybody asks the same question. Who does the child look like? And I always say, my in-laws think that she looks just like them. But that's a photo of Jim and me. And we really weren't polar opposites. There was so much that you could learn from, a great trial lawyer. But I decided that I wanted to be me. I didn't want to be him. I saw lawyers imitate him. I had a great lesson that I was taught when I was a young lawyer that translated into, I don't want to do things exactly the way Jim was teaching me, because it wasn't going to work precisely. Jim had a way of laying down the gauntlet, giving a demand, and that was it. And so I wrote a letter. I was assigned a death case in Syracuse, New York. It was a very good claim. It was an anesthesia case. Boy unnecessarily died. He had a broken ankle. All you need to know is he had a broken ankle, and he ended up dead the next morning. So something had to have happened. And I was given the case, but what I didn't have an appreciation of until I went cracking in the law library — we actually used to go to the law library then, not electronically — was that in New York, the damages were really de minimis. There was no award for economics. There was no pain and suffering because the death happened under anesthesia. And there were no, at the time, I believe, grief damages. Basically, it was a case in search of damages. And so I nevertheless went up to the courthouse. The judge, of course, knew me as a young man and knew the defense lawyer, a fellow in a tweed jacket. I can still see him to this day, as Fritz. And it was Fritz and me. And when we came back, I reported my findings to my boss, and he told me, write a letter and tell them they have 30 days to pay up or else. So I wrote the letter. And I got it back in the envelope. There was no email. Everything was done with 10 or 12 cent postage stamps. And I got my letter sliced open, but my original letter back 3 days later on my desk. And I opened it up, and in pencil, not in pen, but in pencil, my opponent, Fritz, wrote, Tom, someday you are going to be one hell of a lawyer. Fritz. I mean, I said to myself, I wasn't taken seriously. And I coulda, shoulda gone about it a little bit different way, and maybe I should have gone about it my own way.
Right.
There were a whole bunch of lessons, a whole bunch of knocks, a whole bunch of hard knocks that come along the way.
That's true. Show that picture of Tom and Beasley again. You know what? It occurs to me too that when we think about great trial lawyers, if somebody said, what's a great trial lawyer look like, you can't really give an answer to that. There's no stereotypical. I've been to a lot of the AAJ programs, a lot of the people that I've never seen before, and I'd see somebody stirring in the beginning of the program, and I wouldn't really think who it was, and all of a sudden they'd get up and bam, you would know that guy, that woman, that's a trial lawyer. And it always occurred to me that there is no stereotypical look. You don't have to be tall, short, fat, skinny, whatever. It's what drives you inside. It's your ability to connect to the jury. It's your ability to explain to them someone else's plight in a way that they get it. And that's really the reason why I've asked you all the questions that I did, before we took the break, to learn something about you, because I think that what you do in a courtroom, and I have seen you try a couple cases, you bring to bear all of your life's experiences, and in doing that, you connect to the jury. I mean, if people are out there saying to themselves, what relevance does it have that Tom bowled? What relevance does it have that Tom played the accordion? I think it has total relevance to who you are and what you bring to bear in a courtroom and how you relate to that jury, so that they understand that, they understand your background, and they understand, what your life's experience was. And don't you think that's really what it really takes? I mean, everybody out here has a different life's experience. And in my point of view, it doesn't matter if you come from a poor background or a rich background, a privileged background, working class background, but it's kind of knowing where you came from and knowing what values are about life and being able to translate that to a jury. I mean, is that,
I agree. Agree. But there's an awful lot of emphasis because for some reason, I mean, it's not for some reason, there are good reasons why many trial lawyers, especially in Jim's generation and even in my generation, became plaintiffs' lawyers. The fact of the matter is that you can grow up in a very patrician background and be a very excellent trial lawyer. And there's just a way of understanding who you are and how you communicate with people. But you can't, it just falls back to a fundamental. You have to be yourself, and you have to figure out what your abilities are and your limitations are and your strengths are. I mean, I believe, and we haven't touched on this, but there are many places where, first of all, the trial bar is underrepresented in terms of women, especially women who have become successful and frontline trial lawyers. But some of them some women are excellent and more suited, and they have some great strengths in both the way they appear and the way they would present a case. They just have to know and recognize and utilize that. What I don't believe in, going back to something earlier, is just trying to, quote, play to the jury. You have to be yourself. You have to start out with the fundamental proposition that you are going to present the case and win someone's respect. It's very much akin, in my view, to the way that politics, especially current electoral politics, are set up. In a fashion that you have to convince somebody you have a message, you have a short amount of time to do it, and you don't have to be them to get their vote, as evidenced by Barack Obama. You have to have something that they admire, they respect, that they believe in. If all of those things are there, then you're on the right side of where you need to go.
Right. We probably have about 10 minutes left, so let me just run through a couple things. I had about 15 pages planned, I got through 5. So I'm going to try to go through a couple things, and I'm just curious myself. When we talk about a trial, and this is something that's kind of always debated, if you had to pick one part of a trial as, in your view, being the most important, the part of the trial that gives you the best chance to convince that jury, of the different parts of a trial, what part would you say would be the most important?
Cross-examination.
Tell me why.
I believe you can win a case in cross-examination. And I believe that if you are disciplined and meticulous and dogged, that you can win the case.
Okay. You had said before that you don't typically call the defendant as of cross. Is that correct?
Not typically, but I do in the right circumstances.
Okay. So if you think it's a particularly weak witness, you would call him and see what you could get out of them and basically prove your case through the defense. Because, in medical malpractice cases, what I always think, and one of your take on it, is that the jury in a medical malpractice case is always looking to hear from the defendant. Just like in a criminal trial, this Casey Anthony trial that's on now, they're waiting to see if Casey Anthony is going to get on the stand. I think the same is true in a medical malpractice case. When you keep talking about the doctor, they really want to hear him. And in a lot of cases I try, I think my win percentage went up more when I call the defendant as of cross, because once I can get some good points from him and then take him off the stand and then put my experts on and say why that guy that they just saw the day before screwed up, I just think from my perspective, I'm increasing my chances of winning. So I was wondering your perspective on that.
I think it's case specific, Ken. I think that there are enough cases. I don't know my percentages in terms of the number of cases I do and I don't. I tend to do it with a great degree of thought, and I don't like to just say I think that it's an advantage. I think that if it backfires, you're done. Conversely, in a product liability case, almost uniformly my method of trying that case, and I know I see it the same as Shannon, is that uniformly we will call the corporate representative or a corporate representative as the first witness, because there the case is document intensive. It doesn't really matter who that person is. I want to go through the documents for a day or two, have my say about them. It frankly doesn't matter what the witness is saying, and I want to establish the case. I can't do that in a medical malpractice case, because the doctor is going to have an opportunity, if he is or she is both well-spoken, intelligent, and well-liked, is going to have an advantage. And you start with the disadvantage that people generally in the communities like their doctors. So you have to do it with some care. If someone missed a pathology slide, will I call that person first? Yes. Will I call a doctor first just to fight with him or her? Absolutely not.
Right. Okay. Do you have the Pizza Kelly clip? You want to set this up, Tom? I know that this was a deposition that you took, and now that we're talking about cross, this is the Pizza Kelly clip. And you tell us a little bit about that.
Sure. We picked this clip out. I had actually mentioned it to you in some discussions. Tried a case now many years ago involving a boxer. His name was Dennis Richardson. He was in a place called Champ's Gym at, I believe, 16th and Girard. I made a visit there. I was asked by the guy at the door whether, quote, I was running for mayor. I tried the case for a number of weeks. The defendants had unavailability of this witness, Dr. Kelly, who was running an emergency room. The case involved a boxer. He had a subdural hematoma. The hematoma was diagnosed at the local hospital a couple of steps away from the gym, literally. It had to be evacuated. It was a medical emergency. He needed to be transported. The method of transport was the 911, was the Philadelphia Rescue Squad, referred to by Mayor Rizzo many years ago as Dial-A-Prayer. And the issue in the case was why the nurses left the guy with the subdural hematoma sitting on a gurney on the way out the door for well over an hour. And in my view, my simple view, and a lot of these things boil down to very simple propositions, was why they didn't make another call. So the defendants were put up this expert, and the case settled, I think, the morning after the evening that we took this deposition. He was well qualified, nice enough man, as you're going to see. The film is older than The Hill. It's my favorite, so I use it all of the time. And again, here there was nothing premeditated or no sitting up all night thinking or writing out this examination. I basically decided, and I give you this preview because that way when you hear it, you'll know it, because the tape is a little old and rough, translated from an old VHS tape. But basically, my cross-examination, it struck me, during the examination, I might add, that they didn't make a phone call here. And what was the basic analogy to it? And I said to myself, geez, what happens if you order pizza or Chinese food, or you're waiting for a taxi, and what do you do? What do you do when that happens? And here, this Richardson had life and death. And their position was, geez, it was the city of Philadelphia that screwed up. We called, and he was no longer our problem. And so here's that's the setup for this piece. It's very brief.
Dr. Kelly, let me ask you this. There are times when you don't get certain non-emergent services that are in everyday life, that if they don't happen quickly, you make a call back, correct?
Yes.
For example, sir, you want to make an appointment. It's not life or death. It's not whether you're brain damaged for the rest of your life. It has to do with whether you're going to make the theater or dinner. You've had that circumstance, haven't you? Where you'd call a taxi?
Yes.
And the taxi doesn't come for a half an hour. Call back, don't you?
Yes.
Dr. Kelly, you ever order pizza out?
Objection.
I object and move to strike.
You never order pizza delivery?
No.
You ever order any kind of...
Gives me heartburn.
That's fair enough. How about without the tomato? You ever order any kind of food to be delivered to the home?
Sure, like Chinese food, maybe.
Okay, we'll go with Chinese food. You place the order, and you're waiting for 45 minutes, and they still don't come with the food. You call back and you say, "Is my order on the way?" Correct?
Yes.
Objection.
And, sir, for an ambulance, for Dennis Richardson, he deserved the same kind of call that you would make for your taxi cab when you were waiting to go to the theater, or for the Chinese food that you didn't get delivered. Correct?
Objection.
Yes.
He would deserve a lot better than if your Chinese food was running late. Correct?
Yes.
That's my point about cross-examination. You know, why not take a chance? And by the way, if the answer were the opposite, who cares? Who cares? That's right.
That's true. I mean, we only have a couple minutes left. Let me talk about closing for a second. And you had mentioned earlier that when you've done openings and closings, that you would allow yourself to get emotional. And sometimes you'd cry. I actually bump into a trial lawyer every once in a while, George Young, who practices here in town. And every time I see him, he always kids me because he always says that, you know, Rothweiler cries in all of his closings. Do you think emotion is like that is appropriate?
I've never had a ruling. Actually, I have had one ruling. A trial judge who many of you in the room would know told me there will be no emotion in this courtroom. But barring that one experience, I didn't let that stand in my way, by the way. I believe that emotion is part of the human experience, so we're entitled to it. And I don't look to do it. That's the funny part. I do not set myself out to get emotional about it. Just like earlier today, I was a little emotional, and I tried to hold myself when I saw my mom's picture and was talking about her fondly. But I don't set out to do that. So if it happens, I think it happens. And that's just the way it is. It's part of life. So I don't say to myself, I'm going to get myself worked into a lather, because I'm just not that good. I'm not that talented. But it often ends up that way. I don't quite know why.
Do you have the video clip of the closing? Let's show a video clip of a closing.
Yeah.
Good. You want to set it
It's
up?
the only other thing that I brought pre-prepared, and I'll set it up. This comes from the Trialist Theater CLE. It's a reenactment, so it's not done quite with the spontaneity that it was done with in the courtroom. But I had a case involving the death of a youngster at a swimming pool at a day camp who was 8 years old, a handsome young boy who was left unattended, and through a whole consequence of very bad conduct, he ended up dying in the pool. Wonderful parents, and just heartbroken, understandably. And the case boiled down to an economic claim. It was a case tried in Philadelphia Common Pleas Court. Boiled down to the economics, which is everyone in this room knows are viewed suspect by juries. I always in voir dire always explain to jurors, this is a parenthetical, but I think a reasonable point to make here. I always ask jurors if they're able to award those kind of damages. I try to explain that in this case, one of the elements of damages is going to be pain of suffering. Another is going to be the economic loss for a child who's 8 years old, who's never lived. Are you able to, number one, grasp that concept? Number two, are you able to go with it? A lot of people raise their hands and say no, by the way. They say that's all speculative and dumb, and I say this is the law, and I'm going to come back and ask you to follow the law. Are you going to be able to do it in voir dire? Well, here I have closing, and I have just the economics in the case, which I know often are looked at with a skeptical eye by jurors, and I have 2 minutes of pain and suffering. And we had testimony in the case about the horrors of dying with dying by drowning, suffocation. It's a horrible death by all descriptions. and I had a biomechanical explanation of what happens and how the airway shuts down. And I decided to translate that into the mind of the boy. And I was prepared. There were no objections. When you see this, I'm sure someone would raise their hand if we had the time and say, was there an objection? There were no objections, but I was prepared to defend it as a logical, fair inference from all of the evidence. And I took all of the nice, sweet testimony that we had from the family for all of the trial, and I translated it into the boy's head. So I had what he was thinking about in the last 2 minutes, and I had a clock, and there's a counter on the screen, and I had a clock. And I did it a little bit different at Trial as Theater, because you'll see the words come up. But I literally stood in front of the jury and simply read what I thought that this young boy had to have been thinking through the fair description of the evidence. And again, it's a little stilted, it's a little different than being in a courtroom, but I thought that it was representative of what kind of closing I like to think about and like to craft, because it is a craft, and it is worth thinking about what you're going to craft. So with that all in mind, here it is. But I have something more important to talk about, his pain and suffering. It's so horrible. And so hard to say what amount of money to award for his pain and suffering. The defendants tell you, when you really strip right through it and you cut right through their argument, they tell you, you know what? It wasn't all that bad. It happened essentially painlessly and quickly. No more than a minute. Maybe 2. And it's over. And what are they looking for? For a minute or 2 of pain and suffering? He was unconscious very quickly. I asked the rhetorical question, if it were that simple, if it really were that simple, would that be the way we would euthanize our pets? Or maybe put to death our criminals? We know better. We know the science. You've heard one of the leading experts on drowning come into this courtroom. And we spent a day, a solid day, talking about the mechanics of drowning. Why? Because it is important to understand every detail of what Anthony went through. The conscious inhalation of water, the feeling that someone has a clamp on your windpipe, the breastbone is up against your backbone, you're suddenly deprived of air, you're conscious all that time, your blood pressure is dropping, you feel helpless, a sudden laryngeal reflex, loss of consciousness, and then you die. And when they carve you open like they did this little boy's body, they find lungs that are twice their normal size, sinuses full of fluid, cavities full of blood. A little boy who was playing and splashing and left unguarded 2 days earlier, 4 days earlier.
Well, I just wanted to thank everybody for coming. I know it's early, but the fact that we have this kind of crowd is we very much appreciate it from PAJ. A couple things I want to do just in terms of housekeeping is just make sure everybody has their forms, make sure that you sign it, make sure at the end you give it to the staff people here at PAJs. We want to make sure that everybody gets their credits. A couple things. First of all, you'll see that this is being filmed. We have the assistance of our business partners, and I think you probably will have heard throughout this retreat how important the business partners are. They're a vital part of our organization in terms of keeping us financially sound. So it's important, very important, that we patronize them, that you talk to them, that you find out about their services, and then if you give them a call, and they can really help you out in terms of your litigation needs. First of all, I just want to tell you that Precise Incorporated is here. They're a full-service litigation support company specializing in electronic discovery, trial presentations, custom graphics, medical illustrations, and animations. And we use them in my office, and they're great, so I would recommend them highly. We also have our sponsor of this program is Garrettson. Mike McCullough is here from Garrettson. I'm just going to have Mike come up and just give you a 30-second pitch about his company. But before I do, Mike, I just want to say that my office has been using Garrettson. We do some mass tort work. They've been instrumental in helping us get the situations resolved in terms of cases. So, Mike, why don't you take it and just tell folks what you do.
Thanks, Ken. Nice and loud there. Thanks, Ken. First off, we really appreciate the opportunity to sponsor this program. And also, we've been involved now with PAJ for a number of years, and this is a great organization. I personally am involved with about 15 states' organizations, and by far, PAJ is the best out there. No doubt about it. Well-organized group. As far as Garrettson, one of the things that you folks deal with on a day-in, day-out basis is the bottomless pit of nowhereness called Medicare. And our goal is ultimately to help plaintiffs' firms navigate Medicare and get the process done from start to finish as efficiently and as clean as possible. So again, I appreciate the opportunity to come up here and just speak for a few seconds, let you know that we are out in the hall at booth, and I'm more than happy to help you case by case along the way and get you through the process. So thank you very much.
Thanks a lot, Mike. Let me just tell you how this course came about. As a lot of you probably know, I'm the incoming president of this organization, PAJ. And when we started planning this course about 3 or 4 months ago, I sat down with Lisa, and we talked about what kind of programming do we want to have. And when I think about programming, since we're all required to fulfill the Supreme Court requirement for CLEs, what I thought about is, what would I want to see if I came to a course and had to sit for a couple hours and listen? What would I want to listen to? And what I thought about was, things about trial, perceptions about, what you need to do, what the reality is, what the unreality is, and just all the thought process that goes into a trial. And when I thought about that, I thought to myself that the person that I would want to hear from is a person who's done it year after year after year in all over the state, both in Philadelphia and all of the counties in Philadelphia, and that person's Tom Kline. Tom's been my friend for probably 25 years now, and I can tell you the first time I met Tom was about 25 years ago, and it came as a result of a course. Jerry Litvin had given me a call, and he was putting on a course, and it was called Maximizing the Verdict. And he had 5 of us give closings. I was a young lawyer at the time, and I met Tom for the first time, and after I gave my closing in front of the group, Tom went up and then he gave his closing. And I knew at that time that there was just something very special about him. I was captivated by his approach. I was captivated about the way he strung the story together in order to tell the story about his client. And I said to myself, this is a guy that's really special. He's been great to me over the years, and I said to Tom, I'd like to do this course. Let's give it a shot. Now, I have to tell you something about this. There's absolutely nothing about this that's rehearsed. As Tom is sitting here, he really doesn't quite know exactly the questions that I'm going to ask him. And for someone like Tom, that makes him a little crazy. Because I think what you'll find out is the reason why Tom Kline is a great lawyer is because he prepares. Pretty hard to prepare for this. We spoke briefly last night, and he said, what do I need to do? I said, you just need to basically answer the questions. I mean, the preparation really came from me. I was up till 2:30 preparing, thinking about the questions that I wanted to ask. So understand that this is kind of all the thoughts that I have with regard to questions about trial that I wanted to, kind of shoot at Tom. So we're just going to, the whole purpose of this is to get his perspective on trial law.
I was fast asleep.
I'm glad you were, Tom, because as you were sleeping, I was up writing. Tom, when I thought about it in terms of trial work and the qualities that a trial lawyer, needs to have, what would you think would be two of the most important qualities a trial lawyer needs in order to be effective in a courtroom?
Well, the first quality of any good trial lawyer is consistency and discipline. When you're in a courtroom, you're in a very disciplined, very structured environment, and you have to know that that's where you are and what you have to do. The second thing, which is a branch off of what I think is an important quality in life generally, which is loyalty, is sincerity. You have to be sincere to yourself, to the jurors, and to the court, and honest. People see that, they recognize it, they know it right away. I've oftentimes, in fact, I think I remind myself of this almost every time that I set foot in a courtroom and I see a jury. I view our reservoir with any jury as a glass less than half full. We're the subject of ridicule, we're the subject of propaganda, we're the subject of a lot of things that demeans lawyers generally and trial lawyers specifically in the public view. And so when you walk into a courtroom, I view our job as diminished in that way by the fact that we literally have to go in there and face the glass half full with every jury. I'm not talking about county by county, I'm talking every jury. And so I view it as mistakes or loss of credibility as being fundamental not to allow to happen. And that means that the very fundamental building blocks that you live by, which are honesty, loyalty, integrity, are magnified in that setting, magnified to the point where you really need to understand and you really need to focus on never losing it. And of course, you can lose it in many ways, and people who are part of your case can lose it for you. And it's very hard, and the way I've conceptualized it over the years is it's very hard to put any additional fluid back in to get you over 50. Now you know it, sometimes you're trying that case, and sometimes your opponent has made those mistakes,